Good afternoon and welcome to DWD's first Expert Witness webinar. My name is Richard Greeves. I'm the Managing Partner of DWD, and today we're considering the issues involved in accepting an Expert Witness introduction. Joining me will be two of my fellow partners and Expert Witnesses themselves, Andrew Pilbrow and Peter Roberts. The format of the webinar will comprise an introduction to DWD and a run through those areas of property and planning where DWD can support litigation and mediation through our panel of expert witnesses. I'll then hand over to Andrew Pilbrow, who, after an introduction to his areas of expertise, will guide us through the relevant considerations upon appointment of an expert witness. Andrew will then pass the baton to Peter Roberts, and Peter is going to tackle the issues surrounding engagement of an expert witness and paying for that expertise. Finally, there will be an opportunity for you to question our panel, which you can do through the chat function. My experience as an expert witness includes acting on commercial, residential and mixed-use property disputes, predominantly in London and the home counties, and that is in support of both litigation and mediation. And I've been called to cases which arise often due to the professional negligence of lawyers, accountants and surveyors. DWD has one of the largest teams of expert witnesses in the UK. My partners Alan Vickery, who is an expert on business rates, and Jeff Bullock and Sarah Price, who are experts on planning matters. DWD, a little bit about us. We specialise in complex planning and valuation matters. On the planning side of the business, we are heavily involved through the DCA process on both infrastructure, renewable energy and carbon capture projects. And we also undertake planning work on both commercial and residential development, specialising in distribution, self-storage and education too. On the valuation side of the business, we advise on compulsory purchase, business rates, landlord and tenant, and then more specialist areas such as ransom, marriage value and riparian property, including bridges and tunnels. We also advise on the valuation impact of easements and restrictive covenants, both for developers and landowners. I'm now going to hand over to Andrew Pilbrow, who will consider the appointment of an expert witness.
Thank you, Richard, and good afternoon to you all. For those of you who don't know me, this slide gives a brief resume of my experience. I began my career in the early 90s in the valuation office in the civil service, where I qualified as a chartered surveyor. A large part of my career has been involved in property litigation support work in some form or another, and that expanded that role really following the global financial crisis when I began to specialise in further. I've given evidence in the High Court, including very recently in November last year in an alleged breach of fiduciary duty case. And I've also given evidence in the High Court in respect to professional negligence cases. I'm regularly involved in dilapidations cases, Section 18(1), where many of the audits will know me from. Also involved in banking litigation cases involving swaps, interest rate claims, and breaches of covenant, together with other cases where diminution in value needs to be assessed. Got involved currently in a large case involving the application of Rylance and Fletcher concerning contamination issues. Of course, many of the cases that we are involved in collectively are resolved in mediation without reference to courts. In addition to the expert witness role, also undertake non-contentious valuation, red book valuation work and lease advisory instructions. Anyway, that's enough of the sales blurb. We'll go on to the main subject matter today. So what am I going to cover this afternoon? Well, these are the bullet points set out on this slide, which I'm going to deal with in turn. So the first question I ask myself is, does the dispute fall within my area of expertise and geographical reach? So when I'm approached by an instructing solicitor, these are the two questions I ask myself. The first element of this question, it's key, clearly, that experts must not accept appointments outside of their expertise. Well, sure, this should go without saying for the audience, because if they do, experts and their shortcomings are likely to be exposed by legal counsel, both on their side of the dispute and also more so on the other side of the dispute. And this can have implications in terms of reputational damage. And if the case goes to court, obviously there could be a published decision which could be adverse to you. And then the second element of this claim is we must look at the geographical reach. And this depends really on the dispute and the necessity for local knowledge in dealing with that dispute. Question I ask myself, is local knowledge key to the opinions I'm going to be given? Because often there are cases where you can involve local agency experts to give you that opinion or to reinforce your opinions and rely on them in terms of in terms of your evidence. And this happens quite regularly, for example, in dilapidations matters where I might be asked to give opinions in terms of diminution in value in relation to areas which I don't have particular experience in geographically. It's very much on a case-by-case basis, really. One also needs to ask yourself whether you're familiar with the law in the territory where you're acting. Those of us that work in terms under the English law system, then one has to question whether you can potentially act as an expert in Scotland, where there is, of course, different landlord applying. So the next question that we ask ourselves in an approach to accepting instruction is, are there any conflicts of interest in accepting this instruction? Again, for those of us, this is a very common part of professional practice, and it's a mandatory requirement for chartered surveyors who must comply with the RICS mandatory practice statement, which was published in March 2017, and it's effective from the 1st of January 2018. We ask ourselves whether a member or firm has had any involvement with any of the parties or the properties to the dispute. We tend to go back over 5 years to ascertain that, but any known involvement should be disclosed. It's also important to remember that the requirement for conflicts of interest is an ongoing requirement during the life of the instruction. The RICS practice statement says on this point, members and firms identify actual and potential conflicts of interest throughout a professional assignment and do not provide advice or services where a conflict of interest or a significant risk of one arises, unless they do so in accordance with the current editions of conflicts of interest and the RICS professional statement. And of course, in addition to this is our overriding duty to the court in respect of the impartiality of the evidence that we give. So moving on to the next question is to ask oneself, has there been a correct drafting of your instructions? In considering this, I ask myself two questions. Firstly, have the correct questions been asked of me to opine on and to deal with the nature of the dispute in hand? And secondly, are the opinions of other experts needed to assist me in arriving at this opinion? I find that instructions are often given in a draft format, allowing the expert to comment on these should there be any need for these to be modified or expanded on. Clearly, the drafting of the correct instructions is key when it comes to cross-examination down the line, when these matters will be looked at in detail by opposing counsel. And again, any shortcomings are going to be exploited in that position. So that brings me on to whether there are any other experts required to assist in giving my opinion, and whether this is going to involve the project management of these experts, and or is there internal assistance required from fellow colleagues? So this question kind of naturally flows from the preceding one. I'm regularly involved in matters, for example, where input of other experts are needed. And this is commonly building surveyor experts for dilapidations disputes, quantity surveyors for dealing with build cost inputs into development appraisals, town planners, when we're looking at change of use options and the probability of obtaining consent in these examples. Other examples of experts include geotechnical soil experts and those who are expert in aerial photography. Question I also ask then is, if other experts are involved, does my role involve the project management of these experts, or is that the role of my instructing solicitor? This can clearly vary on a case-by-case basis, but frankly, it's my preference for the management, the project management of these experts to be undertaken by the instructing solicitor. We also need to consider whether you need to involve any other colleagues within your firm in terms of performing your role. I commonly involve junior colleagues in my expert matters. It's clear that you must state what their involvement is, not only in terms of your acceptance of instructions, but also in terms of your reporting. It's also important that you check any work that they've undertaken, because ultimately it's going to be your opinion that you're tested on. So next and final question is, are the timescales for reporting reasonable and achievable? I mean, there are many times when I get approached to report in what is frankly a ridiculous time frame. And in my experience, it's best for experts to decline these instructions, as these instructions very rarely go well. Frankly, a rushed opinion can be a bad opinion, and an expert shouldn't accept an instruction where you don't have time to properly resource it. If the case has been properly managed, frankly, this should not happen. But it should be driven by, ultimately, by the client, who's looking sometimes to hedge their bets in the later appointment of an expert. But hopefully this doesn't happen too often. Frankly, from my perspective, I tend to decline these instructions. Thank you. And the final point that I want to cover really is the expert's overriding duty is to help the court on matters within their expertise, and this duty overrides any obligation to the person from whom experts have received instructions or by whom they are paid, and that's the key takeaway. I'm going to pass you over to my partner.
Thank you, Andrew. There we go. Thank you, Andrew. Good afternoon, everyone. I have set out a summary of my experience in the field of expert witness work on the slide. But in brief, my specialisms comprise residential, commercial, development and energy-related matters ranging from contractual disputes, such as option and overage agreements, to the discharge of restricted covenants, together with statutory compensation and compulsory purchase disputes for both acquiring authorities and landowners. Like Andrew, I spent my early years in the Valuation Office Agency and spent 11 years advising on compulsory purchase and rating disputes, including the presentation of evidence to the Valuation Tribunal and then the Lands Tribunal, as it was then known as, before joining a national surveying practice in 2000, where I was part of the team involved in the Park Royal, Guinness and Railtrack case that went all the way to the Court of Appeal. This was just the first of a number of cases I was involved with concerning what is euphemistically described by Network Rail as shared value. I also advised in respect of various development-related disputes. I joined DWD in 2018, since when I have continued to provide evidence to planning, DCO and CPO inquiries, as well as the Upper Tribunal, County and High Courts. Possibly the most high-profile case I've been involved with in the last 3 years concerned the former steelworks and deep water facilities in Redcar, which continues to feature in the local and national press, including The Guardian and Private Eye. I accept direct approach and RICS appointments to act as an independent expert in non-rent valuation and development-related disputes. In addition, I'm a part-time valuer member of the first-tier tribunal, which, apart from introducing me to areas of work I wouldn't otherwise be involved with, allows me to gain an appreciation of expert witness evidence from the other side of the telescope and see it from the point of view of the recipient. Moving on to the next slide, please. Andrew has helpfully set out the initial considerations to be taken by an expert witness in considering whether or not they should consider accepting an instruction. I would like to pick up the baton by diving into the protocols and regulations that should be paramount in the mind of both the expert and the instructing solicitor in taking the instructions forward to the next stage. The courts expect from the outset that an expert will consistently demonstrate 4 key qualities. These are honesty, professionalism, truthfulness, and impartiality. These are like the writing inside a stick of rock in that they should be core to everything the expert says and does. Starting with case law, which is the first on the slide, first bullet point, I'd imagine that most, if not everyone on this call, is familiar with the principles of case law and court rules. Hence, I don't intend to spend much time on the case law and court rules other than to set the scene. However, I do intend to spend a little bit more time going through the RICS regulations. This is probably an area that is less familiar. Dealing with case law, I'm sure that everyone is familiar with or has come across at some point the Icarian reefer case. This case, which dates from 1993, so quite a while back now, sets out a number of principles, but I intend to focus on only 2. These are, firstly, expert evidence presented to the court should be and should be seen to be the independent product of the expert, uninfluenced as to form or content by the exigencies of litigation. I had to look up the word exigencies, need or demand. 2, an expert witness should provide independent assistance to the court by way of objective, unbiased opinion in relation to matters within his or her, indeed, expertise. The point of the expert is to assist the court in understanding matters that do not fall within the court's expertise. The court can be assumed to be familiar with the law and will hear arguments from counsel. Hence, they do not need the assistance of the expert to understand and apply the law. However, the court is not necessarily an expert in the property market, and therefore the expert is there effectively as an advisor to the court. The advice should therefore be, and indeed must be, independent, unbiased and objective as the court or tribunal itself is. In this regard, I had to take the judicial oath on becoming a member of the First Tier Tribunal. This includes the statements that I will do right to all manner of people after the laws and usages of this realm, without fear or favour, affection or ill will. An expert should similarly stay above the emotions of the case and similarly act without fear or favour, affection or ill will to the court, their client, and sometimes it's difficult, I know, but also the opposing side. The second pillar comprises the actual rules of the court to which evidence is being given. Most of us, I would hope, would be aware in the civil courts of the civil procedures rules and be aware of Part 35. Again, Part 35 emphasises the independent expert should be independent, should be uninfluenced by the litigation, and that they should provide objective, unbiased opinions on matters staying within their expertise, and they should at no point assume the role of an advocate. It's interesting that the Upper Tribunal, who also have their own rules, known as the Practice Directions of the Lands Chamber of the Upper Tribunal, these came to force in October 2020, they take this point a stage further, adding, an expert who is to be paid on a contingency basis may not give evidence. Payment on a contingency basis means any arrangement that leads to the expert having a financial interest in the outcome of the case. It includes any agreement that all or part of the fee paid to the expert or the expert's firm as well. This can sometimes arise in Section 18 cases, for example, where the building surveyor and the valuer come from the same firm, is related to the degree of success achieved in the proceedings by the party instructing the expert. Woe betide the next rating surveyor who tells the Upper Tribunal that it is perfectly all right to appear on a success fee basis, as it is entirely compatible with being independent, unbiased, objective and impartial. We now come to the RICS practice statements, the RICS requirements. There are a number, but the main one is called Surveyors Acting as Expert Witnesses, 4th edition. Compliance with this statement is mandatory under Rule 4 of the Rules of Conduct for members and applies to all expert evidence in whatever form or sphere it is provided. There is no latitude or ability for the surveyor to opt in or opt out as they wish. This practice statement comprises 10 mandatory practice statements and 21 guidance notes. I'm sure you'll all be extremely relieved to know that I do not intend to go through each one of the mandatory statements and the guidance notes. I think that would probably finish us all off. However, I do want to consider those sections particularly relevant to today's subject. The practice statement defines the expert's role in a number of ways, but similar to what we've already said, but it stresses, PS2 stresses your overriding duty as an expert witness is to the tribunal or court. This overrides any contractual duty to your client. Your duty is to set out the facts fully, giving truthful, impartial and independent opinions, covering all relevant matters, whether or not they favour your client. A number of conversations sometimes with surveyors asking whether they should include certain evidence in their report or not. The answer is you set the facts fully. You set out your evidence as fully and independently as possible. Special care must be taken to ensure that the expert evidence is not biased. Opinions should not be exaggerated or seek to obscure alternative views or schools of thought. Instead, where appropriate, you should recognise them and address them. And there's also the other point, you must not malign the professional competence of another expert witness. This last point does amuse me, as rent review surveyors tend to consider it a badge of honour to be as vicious and as insulting as they possibly can in criticising each other in their written reports to the independent expert or arbitrator. But whilst a valuer, independent expert or arbitrator may let that behaviour go, albeit taking a view perhaps, it is unlikely that a tribunal or a court would do so. The test really is, how would you feel as an independent expert if your comments were read back to you in open court, in front of your team and the opposing team, and in front of the target of your comments? If you feel uncomfortable with your comments, then don't say it. Leave it to your counsel to make withering comments as they see fit. The next point on the slide is the question of fees. The practice statement sends a clear message to members that you should not undertake expert witness appointment of any form of conditional or other success-based arrangement, including where those instructing you are engaged on such a basis. This echoes the upper tribunal direction I referred to earlier. Put simply, there is no room for anything where the fee basis is somehow related to the outcome of the case. The next bullet point is the preparation of a budget. Again, I'm going to refer to the RCS practice statement, which requires the valuer, the expert, to set out clearly in writing the scope and basis of our fees. This might be by reference to the work to be undertaken, daily or hourly rates, or a fixed fee. Should also make sure that there's provision in there for additional payments for travelling time, expenses, disbursements, attendance at hearings, and late notice, cancellation fees or settlement after you've been booked to attend a hearing and cleared your diary of all other work. An expert witness is likely to be required to provide an estimate of fees, but such an estimate should only be provided when an expert witness has a good understanding of the case and the scope of his or her appointment within it. We'll maybe come back to this point later on, but I'm often asked to give fee quotes before I'm even appointed. It's just not possible on the RCS, explicitly tell us not to do that. Clients and solicitors often expect experts to act on the basis of a fixed budget and to be able to provide a fixed fee. Whilst I fully understand the need to control costs, I tend to find that, as I've just said, the outset of an instruction is far too early to be definitive with fee estimate. And any expert who is happy to quote a fee, that fixed fee that is perhaps lower than other experts, should trigger a question in the mind of the instructing solicitor as to whether that expert has fully understood the issues and whether the expert will, as a result of securing the instruction on a fixed and maybe reduced fee, then tailor their advice to that fee. It is not a defence in court for an expert to advise that their remuneration did not allow them to carry out the full extent of research or set out their full opinions as they might otherwise have done, simply because the client wished to save on costs. The important message is that a budget can only ever be indicative at the start, and communication is key to ensure that there are no nasty shocks for either the client or the expert further on down the road. Having established the nature of the instruction and likely costs, the solicitor and the client need to finalise terms of engagement. Before getting into the details of what should be included in those terms, I'd like to address the question of whether or not the expert should attach their terms of engagement and their instructions to an expert report. I say this as some surveyors hold the view that terms of engagement should always be attached to expert evidence, and I have personally come under attack from counsel in court, prompted by their experts for not doing so. My understanding of the position is that there is no requirement anywhere within the court protocols or RICS publications for the attaching terms of engagement to evidence, and the RICS goes so far as to advise surveyors not to attach terms of engagement to their evidence. It is open to either party, of course, to apply for disclosure of the terms, but the court will need to be convinced that disclosure is proportionate and relevant. I therefore work on the basis that terms should not be attached to the report, but the solicitor and expert should be alive to the possibility of disclosure later on down the line and draft accordingly. The other issue that follows on from this is whether, as the instruction evolves and further information comes to light, the original instructions need amending and updating. The problem here is if the expert is challenged on their instructions and they have not been updated, the expert could stand accused of straying outside of their instructions and effectively providing advocacy rather than expert advice. With regard to the terms themselves, the RICS practice statement requires the conclusion of the following matters, amongst other things. We are required to provide you, our instructing solicitor, and our client with a copy of the practice statement to go with the client guide, notifying you that our complaints procedure does not apply to our engagement as an expert witness. Our duty is the tribunal, not the client. Ensure that we, without delay, we advise our prospective client in writing the nature and scope of our obligations under this practice statement, so everyone is clear from the outset what our duty is and what our obligations are. We need to confirm in writing, Andrew's alluded to this already, that if any part of the assignment is proposed to be carried out, or we are intending to have assistance from other members of staff or a person other than ourselves, that the client clearly understands that, and at all points during the instruction continue to carry out a conflict of interest check to ensure that there is no compromise in your situation that the expert is not aware of. That has arisen since being instructed. I appreciate that I've rattled through this slide fairly quickly, and if anybody would like to read around these matters in more detail, please email Richard, Andrew or myself, and we'll be very happy to send you the web links to the various documents. But in the meantime, we're going to do a double act, Andrew and myself, and take it in turns to go through the next slide, which effectively summarises everything that we've been talking about.
Thank you, Peter. So I'm going to pick up the first bullet point there, which is the client responsibility for fees. So it's important really for the expert to have complete clarity on who is responsible for their fees. This can either be the instructing solicitor or the client direct. I find many solicitors now prefer for their clients to be directly responsible for experts' fees rather than having to raise disbursements for them and or effectively becoming an agent for payment. This is fine with us and is becoming more standard procedure. There is, however, the issue of dealing with non-payment of fees, a rather thorny issue that occurs every so often. And ultimately, if your fees aren't paid, you do have the reserve the right to take a lien over the confidentiality of a report. We've never had to do that between us thus far, and hopefully that would be avoided.
Okay, just I'm not going to say much about the RICS practice statement and client guide as we've probably already covered it. But as I say, if as an instructing solicitor you've never been presented with a copy of it, we'd be very happy to forward that to you at your request.
Thank you, Peter. Again, we've covered conflicts of interest, and really here to iterate it's at the acceptance of the instruction and the obligation to undertake conflicts throughout the instruction. I'd also like to touch briefly on the issue of Chinese walls, which is a term often employed by very large firms of surveyors in terms of managing conflicts. Certainly in my experience, Chinese walls should be avoided and expert instructions should not be accepted on that basis.
Okay, clear instructions. I would make a plea to instructing solicitors that you do liaise with your valuer experts in the draft of instructions to to ensure that they do actually work and make sense from a valuation as well as a legal perspective. The property market does not always follow legal thinking, and valuers may well approach the problem differently. The less room for interpretation by the expert outside of the terms of engagement and instruction letters, the better. As I have already pointed out, I suggest that solicitors and experts do check the original instructions before submitting their report to ensure they do tally with the evidence being provided, and if necessary, update those instructions in good time prior to submission. This neatly leads on to the next point, which is the identification of the legal matters in dispute. It is usually the case that my valuation evidence and the opinions are based on a particular assumption or interpretation of law. At the point of drafting the expert report, of course, counsel has not submitted any legal argument, and without an explanation as to the legal principles being relied upon, valuation evidence may not make sense as a standalone document. One way to deal with this is to say, for example, I am instructed by my instructing solicitor that, or I have assumed that, or I understand that. However, these phrases are not a panacea, and even though it's quite clear that I'm quoting advice provided to me in my evidence, I have been accused by opposing counsel in court in the past of straying into legal territory. I therefore tend to go, I've started going down a route where I ask solicitors to actually draft up a legal note, which I can then attach as an appendix to my report. So there is a clear distance between the legal matters on which I'm relying and the valuation evidence. It might be helpful if anybody in this call has got any other ideas how to deal with this, but it's important to keep distinction between your expert evidence and the advice that you're relying on in providing that expert evidence. Andrew.
Thank you. Disclosure of documents. I mean, this ties in very nicely with receiving correct instructions, but the expert should clearly ensure that they've got a full set of disclosed documents, and if they think that any documents are missing, then they should ask the question of their instructing solicitor. I'd also tend to ask the question whether these documents, disclosed documents, are common to all parties to the dispute, because that's a very important thing, that both sides or all parties to the dispute have access to the same documents. In the larger cases, this is often done by virtue of a data room. Moving on to the next point, timescales. Again, I covered this earlier on. It's important, we would consider it's important that experts are engaged at an earlier part of the process in order to give sufficient time to undertake due diligence and form their opinions. It's also important that they're given time for their opinions to be fully tested in a kind of wargaming situation almost by their side's counsel, to ensure that the report is in very much apple pie order.
Okay, travelling time, court attendance and joint statements. We'll probably be covering these in a future seminar, particularly the court attendance and joint statements part, where we'll dive into a bit more detail. On the travelling time, it does take time to travel to sites, to inspect them, to make a proper look around the site itself, look around the subject area, get a proper feel for everything that's going to influence the valuation exercise. And that, of course, that takes quite a lot of time to achieve that. I'm not sure it's always entirely appreciated by clients, and instructing solicitors quite how much time and therefore fee that part of the exercise takes. So it is helpful at the outset to have that conversation to understand of the fees. Does it relate to the report writing? Does it also include travelling time and other matters which are quite significant on their own? Andrew?
Thank you. And I'm going to pick up the final point on that slide, which is supportive instructions. These happen from time to time. It's important that the expert deals with this in terms of their terms of engagement, and that any time that they employ on the instruction is properly recoverable. So that brings the main part of the webinar to an end. I'm going to pass you back to our chair, Richard, who's going to pick up any questions that you may have.
Thank you, Andrew, and thank you, Peter. We've got a number of questions. The first one is as follows. The court will only allow one expert per party in the interest of managing time and costs. However, you need input from other specialists to fulfil the instruction, for example, a quantity surveyor. What do you do? Peter, can I ask you that one? And there's a ancillary question to that, you should also pick up. You think the solicitor is asking you the wrong question, how would you deal with this?
Okay. As we stressed on the talk, the expert needs to stay very much within their own areas of expertise. But the trouble with that, if you're, for example, doing residual valuation, you need to have quantity surveying advice in there. The way I tend to get round it is to actually ask for a quantity surveyor's report and attach that in my appendices and make it clear that I've relied upon that report. I tend to take the view that if the other side doesn't like that report and they wish to put that into arena for cross-examination, it is for them to then ask for that to be put into the arena, and that may translate into expert evidence, and there the court or the tribunal will understand why it is important to have that evidence tested in the arena. Sorry, what was the second question?
The second question is, you think the instructing solicitor is asking you the wrong question. How would you deal with this?
I think you have
respectfully, obviously. Yeah?
I think you have to have a full and frank discussion with the solicitor. I mean, I had one recently where this was a rights to light case, and obviously without naming the names, I was being asked if I would do a diminution value for the rights to light, and the advice I had to say to the solicitor, I think you're asking the wrong question. You should be asking us to look at loss of profit here. I suggest you go back and think about this, because whilst I'm happy to give you that advice, I don't think it's going to help you. I don't think there's any mileage in experts ploughing on down the route of giving the solicitor or instructing solicitor or client what they've asked for if they know full well it's not actually going to help their case.
Thank you, Peter. Question here come in. Does the panel consider that a valuer based in central London can act as an expert witness in a location several hundred miles away from their office? I'll attempt to answer that. I think it is very much possible that a central London based valuer can act as an expert witness as long as they have the expertise, firstly, of valuing that asset class, because you might be located 10 miles away from a data center, but if you don't know how to value a data center, you shouldn't be valuing it in the first place. So I think it's important to have the relevant expertise in the asset class being valued, and most firms of surveyors have access to subscription-based data services which enable the collation of information, and you can corroborate that with local agents. It may also be necessary to engage potentially a local surveyor to act as an additional expert if there is a situation where an expert witness based in central London is doing the majority of the work, and there needs to be some ancillary input. So I think it's a qualified yes to that, but I would stress that the class of asset which the expert witness's opinion is required on is key. We have another question here. In your experience, are experts appointed early enough in the dispute process? And I'll ask you to answer that, please, Andrew.
I think the obvious answer, this is not meant to be self-fulfilling, but the obvious answer is that I think experts should be appointed as soon as possible in the dispute. Not only because it gives them time to form their opinions, but it can also help in terms of potential settlement discussions, in terms of the clients instructing solicitors and team, in terms of forming, if you like, the parameters of a dispute. So it's worthwhile engaging experts early on. I appreciate that sometimes clients wish to save the money and hedge their bets a little bit before experts are engaged, but I think it's important that those of us that are dealing with the nub of the issue are engaged as soon as possible to allow the quantum of the claim to be properly assessed.
Thank you. Thank you for that, Andrew. Well, that draws our webinar to a close, but if I could just draw your attention to our next webinar, which is taking place 3 p.m. on Thursday, the 9th of March, where we'll be looking at the expert report and joint statement in more detail. So I hope you found that informative, and I hope you'll join us on the 9th of March. If you have any questions, please feel free to email Peter, myself, or Andrew, and we'll do our best to answer any queries you have. Thank you very much indeed. Thank you. Goodbye.
Thank you.